Howdy, everyone, and welcome to Telemedicine and Telehealth. I'm David Glazer. I'm just here for a second because the presentation is going to be done by Ryan Johnson and Catherine London, who we'll introduce in a second. Just a few quick announcements. So first, our next webinar will be on Wednesday, August 13th. And we are going to be doing, so our most popular webinar to date ever was a frequently asked questions webinar. Steve Beck would call it grab bag. I would call it stump the lawyer. But it's whatever topics we're getting asked on a regular basis. Not exactly sure who all is going to be on it. I know Katie Ilton will be back from maternity leave. She's going to be doing it. I'll be doing it. And I think several of our other colleagues will be doing this on August 13th. The last time we did this, it was our biggest webinar ever. If you've got questions, please send them in. And you can do that either on the evaluation form today, or you can email them. You can email them to any of us. You can send one to Ryan or to Catherine. You can email me. But I suppose the easiest thing, when you fill out your evaluation, just write on there question for next webinar and put in whatever it is, and we will be answering those questions on August 13th. This will be up on SlideShare sometime in the next few days, and you can share it with whoever you want. All of our past webinars, well, all of our last few years of past webinars are up there, and they're free. And finally, sound quality. If it goes south, you can always dial in. You can listen through your speakers, but dial in if something goes wrong. Finally, you can ask questions about today's webinar in the chat box. Actually, if you wanted, you could even type in the chat box and just type for next webinar if you wanted your question in there. So let's turn this over here. We've got Catherine London and Ryan Johnson. Ryan, I remember, did his first telemedicine project with me 15 years ago on a multi-state question, and he and Catherine have been working on this for a long time, dealing with remote monitoring at home, diagnostics, stuff that can help really in any state in the country. They've done it for for-profits, for not-for-profits, for startups, the whole big deal. They're going to walk you through everything you need to know about telemedicine and telehealth. Ryan, I think the questions have gotten harder over the last 15 years, and he'll start us off.
All right, thank you, David. All right, thanks, everyone. So let's get started. Healthcare is experiencing a revolution, as all of you know, driven largely by two forces, information technology and consumerism. As consumers are asked to assume more responsibility for their healthcare, in particular financial responsibility for the cost of their healthcare, one-size-fits-all traditional bricks-and-mortar medicine is increasingly at risk of being overtaken by a highly personalized form of online telemedicine convenience care. Within the past decade, we saw the rise of clinics located in some of the nation's largest retailers and pharmacies. These clinics offer consumers a quick, convenient way of accessing healthcare in a way that causes minimal disruptions in consumers' daily activities. Information technology is opening the door to greater consumer and patient convenience, allowing patients to get medical information at any time and from any location, be it at home in front of their computer or on the road via their iPhone or Droid. These technologies promise to reduce costs, increase convenience and access, and improve healthcare. Today we're going to focus on the legal and regulatory issues of telemedicine with a focus on direct patient encounters, or virtual medicine. Today's presentation will be an overview of the legal and regulatory issues of telemedicine, a 101 course, if you will. We hope to provide additional, deeper guidance on some of these laws and regulations in future webinars or publications. Of course, we'll leave time at the end for questions, and feel free to call or email us at any time if there's something that we did not cover in today's presentation that you have a question about. So today's agenda, first we're going to spend some time defining telemedicine and telehealth. Then we'll briefly look at some of the evolving business models in telemedicine. Then we'll turn to really the meat of the presentation, look at the legal and regulatory issues that companies, providers need to consider when entering into the telemedicine space. Catherine will go over some of the key considerations in telemedicine agreements, and we'll close with some recent AMA guidance and guidance from the Federation of State Medical Boards on telemedicine. So first, what is telehealth? Telehealth is the use of telecommunications and information technology to provide access to health, diagnosis, assessment, intervention, consultation, supervision, and information across a distance. This comes from CMS. This includes communications via telephone, fax machine, email systems, and remote patient monitoring devices used to collect and transmit patient data for monitoring and interpretation. Now, telemedicine is included within this definition. During today's presentation, we'll try not to confuse the two terms, but we may use them interchangeably as we describe telemedicine. So CMS defines telemedicine as the provision of clinical services to patients by practitioners from a distance via electronic communication. And there are two ways this can be done. One can be simultaneously, for example, tele-ICU, or non-simultaneously, which is often the case with teleradiology. Simultaneously would mean that the clinical services, for example, the assessment of the patient with a clinical plan for treatment, including any medical orders needed, are provided to the patient in real time by the telemedicine practitioner, similar to the actions of an on-site practitioner when called by a patient's attending physician to see the patient. Non-simultaneously, probably obvious, but means the after-the-fact interpretation of diagnostic tests in order to provide an assessment of the patient's condition, and do not necessarily require the telemedicine practitioner to directly access the patient in real time.
Ryan, I just have one thing to add there. CMS has never actually defined telemedicine by regulation. That definition was actually pulled from commentary to the final rule regarding the hospital conditions of participation for telemedicine credentialing.
Right, thank you. So, what is telemedicine? It's informal consults between practitioners at different locations. This is not telemedicine. So, so you have to consider how the communication is taking place. Is it with the patient directly, which would be telemedicine, or is it physician-to-physician consults where the patient is not present? CMS does not consider telemedicine to include informal consults where the distance site practitioner provides an opinion to an attending practitioner rather than service directly to the patient. And it's important for both Medicare and for state law purposes to distinguish between these two types of interactions. So, business models. We've seen a lot of activity with telemedicine. Much of this is coming from the private sector space. Many of the new telemedicine models are being financed by private investors, by venture capitalists, by private equity groups, by large corporations, non-traditional players in the healthcare space. We've also worked a lot with physician groups, health systems, not-for-profits, hospitals who are also interested in expanding their provision of telemedicine because it's a convenient way of allowing patients to access healthcare. Some of the evolving business models involve proprietary diagnostic technologies, which allow patients to self-administer simple tests for common ailments, including much of what is currently provided in primary care offices or retail clinics. There are a number of companies that are actually adding on to the telemedicine model at-home diagnostic capabilities. For example, rapid strep test for UTI. These clinics are often staffed by non-physicians. They can be staffed by physicians, but many groups are using lower-level practitioners, nurse practitioners, physician assistants, LPNs, and others. And it's a cheaper way of providing health care. Now, prescriptive authority is often viewed as critically important in making this model work. Patients want convenience, and they don't want to have to be diagnosed online, then drive to a bricks-and-mortar clinic to get a prescription for their condition. And so today we're going to talk about scope of practice, prescriptive authority, to make sure that if you are creating one of these models, patients can get what they need when necessary, a prescription. So some of the legal and regulatory issues we'll talk about today include licensing and scope of practice, supervision and collaboration agreements, prescriptive authority, federal and state privacy laws, reimbursement issues, the corporate practice of medicine prohibition, which comes into play. You have for-profit companies, private investors who are working with the telemedicine providers. I'll also talk a bit about malpractice risk and best practices for risk management with the telemedicine model. And with that, we'll turn to Catherine and licensure.
Thanks, Ryan. I want to just take a minute to reemphasize the point that Ryan made, that this presentation is really intended as an overview of some of the relevant considerations, and in this case, regulatory considerations that come into play in the telemedicine arrangements, and is really just a broad overview, and so we will address as many issues as possible, but if you have questions, feel free to follow up with either one of us, especially with regard to specific state law requirements. So first I want to talk about a key issue in any telemedicine arrangement, and that is the licensing that is required for the healthcare professionals involved. In general, practitioners are required to meet the licensing requirements in the state where the patient is located at the time of a telemedicine consult. And in the state laws really vary regarding telemedicine. Some states, for instance, have licensing laws that directly address and explicitly define the practice of telemedicine. Other states indirectly address this issue by defining the practice of medicine to include diagnosing or recommending treatment through electronic means or through any other types of means or instrumentalities. And then other states, the laws are silent. And it's important to note that when you are considering a telemedicine arrangement, you really have to look at all sorts of different types of sources of authority, including medical board policies in a particular state, medical assistance requirements. It's not just the statutes and regs that you need to review. States also differ in terms of the level of licensure that's required for telemedicine practitioners. Some states require full licensure of the practitioners that are providing telehealth services in the state, whereas other states have special telemedicine licenses. For instance, Minnesota and Montana have some of these special licenses that allow physicians to provide telemedicine services without obtaining full licensure in the state. I also noted on the slide that the state may have active or in-state practice requirements that are necessary for a physician to maintain licensure in the particular state. I also wanted to mention that there are some exceptions that may apply to a potential telemedicine arrangement. For instance, as Ryan mentioned, physician-to-physician consults are typically not considered telemedicine and are also typically often excluded from the requirements for obtaining licensure in a state. And this exception is obviously not as applicable in, say, a telestroke arrangement, but may be applicable in other situations where a telemedicine practitioner is not providing direct patient care via telemedicine, but really just consulting with another provider. And then also some states have infrequent or occasional consultation exceptions. And what this means is that a practitioner who's providing fewer than 10 consults, for instance, to a patient per year in the state would not need to apply for a license to practice in that state. Moving on, I want to talk about an issue that is increasingly important, and that's the use of non-physician practitioners in the telemedicine context, because this, as Ryan mentioned, can raise a number of issues regarding scope of practice, supervision, and also prescriptive authority, and I'll talk about these more in a minute. Some other considerations that are worth noting are the state-specific written collaborative agreement requirements. If you're entering into a new state and considering using non-physician practitioners, you really need to have a good understanding of what type of agreements are required. In addition, some states have really specific requirements about the use of protocols by non-physician practitioners, and this is also especially noteworthy in the remote prescribing context. Another thing that I should mention is the Nurse Licensure Compact is one effort to address some of these issues and to expand access to telehealth services. And under this compact, nurses in member states, meaning states that are members of the compact, can practice the nursing in other member states without obtaining a new license in that state. And currently, there are 24 member states with, I believe, 1 or 2 states that have pending legislation to become part of the compact. So the first thing I want to talk about with regard to scope of practice and non-physician practitioners is physician supervision. And this is especially important in a telemedicine context. And I've included definitions on this slide, which are really just general supervision definitions. You would need to look to specific state law to determine exactly how that state would define the supervision levels, but general supervision typically refers to procedures needing to be performed under a physician's direction and control, but the physician's presence is not specifically required. Direct supervision refers to instances where the physician must be present in the office suite and immediately available. And then personal supervision typically means the physician needs to be in attendance in the room during the procedure. So direct supervision and on-site requirements can really significantly impact telemedicine arrangements. This is especially relevant if you are intending to use, say, a nurse or a PA to provide services to a patient at the same location where the patient is, but say the supervising physician may be located off-site and available just via video consult. It's really important to review state requirements to determine if this type of remote supervision would be acceptable. And I also wanted to mention, when you're considering supervision requirements, some states do have practice ratios, meaning, for instance, in California, a physician may not supervise more than 4 nurse practitioners at any given point in time. Prescriptive authority is an issue in the telemedicine context that is worthy of its own webinar. There are a lot of issues and concerns in this on this topic, and prescribing medication in connection with telehealth encounters can raise a lot of these issues. So the permissibility of remote prescribing varies a lot among states, and again, you really need to look at a variety of sources of authority on this, including pharmacy statutes and regulations, as well as board policy and Medicaid reimbursement policies. On this slide, I've identified some state prescribing requirements that I think create the biggest hurdles in the telemedicine context. And for instance, in several states, physicians may only prescribe to patients with whom they have an established patient-physician relationship. And so you really need to determine what is required to establish that type of relationship and whether that can be done via a telehealth encounter. Often states will have specific face-to-face encounter requirements or physical exam requirements that are needed before a physician or practitioner can issue a prescription. Some statutes will explicitly say that that exam or that encounter needs to be in person, while other states, state laws are silent. In addition, some states will prohibit the use of questionnaires or in-person or internet consults as the sole basis for a prescription. So you really need to take a good look at the state sources of authority if you are going to consider issuing prescriptions in the telemedicine arrangement. Also note that there are some, the requirements for controlled substances are generally heightened and might impose additional requirements, especially with regard to telemedicine. So there have been some efforts to clarify these requirements over the years, and I think we've seen a lot of movement on this, but it is rapidly changing, and a lot of states also have made no changes to address the role of telehealth in the prescribing context. Moving on, I want to talk about another issue that's also worthy of its own webinar, and that is privacy and security considerations with regard to telemedicine. So in general, HIPAA applies to covered entities and business associates and governs the access to protected health information. And I've included here the definition of protected health information under HIPAA, and it's defined as individually identifiable information that's created or received by a healthcare provider relating to an individual's health, provision of health care, or payment for health care, and which identifies the individual or provides a reasonable basis to identify the individual. So HIPAA's security rule requires certain administrative, physical, and technical safeguards that are in place to protect electronic PHI. An electronic PHI is any PHI that's transmitted by or maintained in electronic media. So in general, covered entities and business associates need to ensure that there are protections in place that ensure the confidentiality, integrity, and availability of ePHI that protect against certain threats and hazards to ePHI and also protect against impermissible uses and disclosures of this information. And then finally, covered entities and business associates need to ensure compliance by all workforce members. So HIPAA compliance in telemedicine arrangements is especially important given the increased access to PHI, especially by individuals who may not be employees of the covered entity and may not be aware of the entity's privacy and security policies. And you also need to ensure that a patient has no access to the appropriate notice of privacy practices in a telemedicine consult. And it just increases the risk of exposure to PHI. So it's really important to analyze any telemedicine arrangements, especially if there are vendors involved who are providing equipment and services, and you really need to take a close look to determine whether the HIPAA security requirements are met in these arrangements. So on this side, I've included just some general considerations, and these really apply to any security assessment, not just telemedicine related arrangements. And it's important to consider, your size of your organization, its complexity, its capabilities, and technical infrastructure. You'll also have to really review costs for security measures that are required to ensure you're compliant with HIPAA. Some key examples here we've included on the slide are encryption, user authentication for access to your database and systems, and then also just ensuring that there's a secure network, especially in the telemedicine context. And as I mentioned, this could be a webinar on its own, but we're happy to follow up if you have any specific HIPAA-related privacy and security questions with regard to telemedicine. The last thing I'll mention on privacy and security is that you also need to consider state laws that could potentially apply in the telemedicine context. It's really, really important to remember that HIPAA sets a floor, not a ceiling, and if there are any applicable state laws that are stricter than HIPAA, those laws will control. I also want to mention that some states actually have specific laws relating to telehealth encounters and set forth explicit requirements for record keeping, and also heightened informed consent requirements in telemedicine arrangements. I think Nebraska is one state in particular that has some specific telehealth record keeping requirements. So switching gears a little bit, I'm going to talk now about credentialing and privileging in the telemedicine context. And in CMS, in the CMS conditions of participation, hospitals are required to have credentialing and a privileging process in place for all practitioners who are providing services to hospital patients. And previously, CMS required hospitals to fully credential all, any telehealth practitioners. However, in 2011, CMS changed the COPs to permit hospitals to rely upon the credentialing and privileging decisions of a distant site hospital or telemedicine entity with regard to practitioners who are providing services via telehealth. And under this final rule, the distant site can be either a Medicare participating hospital or a telemedicine entity. So for instance, this could include teleradiology providers, tele-ICU providers, or even ASCs. And I should mention that when I'm referring to an originating site in the next few slides, this is the location of the Medicare patient or beneficiary at the time that the telehealth service occurs. In order for hospitals to take advantage of this credentialing option, there are a few requirements that need to be met. And I have included some of these requirements on the next couple of slides. But for instance, the originating site hospital has to have an internal review of the distant site practitioner's performance and needs to provide this information to the distant site hospital or telemedicine entity, whichever it may be. In addition, the distant site hospital has to provide a current list of the practitioner's privileges, and also needs to you need to ensure in these types of arrangements that the distant site practitioner holds a license issued in the state of the originating a license issued or recognized by the state of the originating site hospital. And these requirements, I won't go in depth, but these are set forth in the COPs. And there's also a requirement for a written agreement between the originating site hospital and the distant site hospital or telemedicine entity. And that agreement has to specify that the distant site hospital or entity will provide the services in a manner that allows the originating site hospital to comply with applicable COPs and other applicable standards. So from that, I want to talk about I've talked a little bit about what type of provisions would be required in a certain telemedicine agreement for, in this case, credentialing and privileging, but I want to talk about some key considerations in general with regard to telemedicine agreements. And on this slide, I've identified some of these considerations that I think are really, really critical. I think the first thing you have to do when you're considering a telemedicine agreement is clearly define all the parties who are involved. Are any subcontractors involved? If so, what is their role? What type of access would the subcontractors have to any PHI? And is there a business associate agreement required? And then also, really, I think the most important consideration is what states will the parties and the patients be located in? And you really have to do a very thorough review of the state laws that are applicable to a particular agreement. Again, what type of practitioners will be involved? As I've just discussed, if you're using any non-physician practitioners, you'll really have to consider the scope of practice requirements and also just licensing requirements in general. And then what type of facilities are involved? Is this a hospital? Are you going to have to deal with some of these credentialing issues? And then finally, will the arrangement involve remote prescribing? Because if so, as I discussed earlier, that can open up a whole other can of worms that you will have to address. Just a few other items here. Remember, some states have laws that apply specifically to telemedicine arrangements, and so you'll have to determine whether any specific record keeping or consent requirements might apply beyond just HIPAA or beyond HIPAA privacy requirements. And what other agreements are needed? I mentioned a BAA might be required, but Ryan's going to talk about some other agreements that might come into play, especially if corporate practice of medicine doctrine is triggered. And then also, what equipment is going to be used in the telemedicine arrangement and how or who is going to be providing or maintaining that equipment. This could trigger fraud and abuse laws and might require further analysis if one of the parties is going to be providing or maintaining the equipment for the other party to the agreement. And then finally, you'll have to identify what type of payment is going to be available for the services provided under a telemedicine agreement and what additional requirements will apply. So with that, I am going to move into talking a little bit about the reimbursement that's available for telemedicine services. And in general, the payors are, as I've included on the slide, employers and individuals, private or commercial payers, and then also Medicare, Medicaid, and other government payers. And I will try to talk about most of these payer sources here today. So starting with states and private payers, there's really a wide range of telemedicine reimbursement policies among state Medicaid and third-party payers. The latest information that I have seen, this is the most recent information available, however, this has probably changed in the 30 minutes since we started talking about doing this webinar. So about 46 states offer some form of Medicaid reimbursement for telemedicine. Approximately 9 states will pay for store and forward technology, and that refers to technology that's not real time, so not the patient, not situations where there's a real time communication between a patient and provider. 14 states pay for some form of remote patient monitoring, and 19 states at this point actually mandate that private payers cover telemedicine services. So again, this is rapidly changing, and this information was from February of this year, but may have changed in the last few months. Here is, like I said, this is from February, and this is the source of this information is the National Conference of State Legislatures, and this just provides an overview of the current reimbursement for telemedicine. Moving on to Medicare. In general, Medicare reimbursement for services that are delivered via telemedicine or telehealth will cover remote face-to-face services that are provided to patients via live video conferencing. And I'm also going to touch on some non-face-to-face services and the reimbursement that is available for those types of services. So starting with remote face-to-face services. In the Medicare context, Medicare will reimburse for the use of a telecommunication system that substitutes for a face-to-face hands-on encounter. And Medicare reimbursement for these types of services is available only if certain very specific requirements are met. And these requirements relate to the location of the originating site, the types of services provided, the type of institution that's delivering the services, and also the type of healthcare professional who is providing the telehealth services. For an originating site to be eligible for Medicare telehealth reimbursement, the site must be either a rural health professional shortage area or located in a rural health professional shortage area, or in a county that is not a metropolitan statistical area, or must be part of an approved demonstration project. And I should mention that there is no limitation on the location of the distant site healthcare professional delivering the service. This applies just to the originating site provider. One change for 2014 is that the definition of a rural HIPSA is now a HIPSA that is located in a rural census tract as determined by the Office of Rural Health Policy. And this can include some census tracts in a metropolitan statistical area. And this actually essentially expanded the definition of a rural HIPSA to include additional HIPSAs as eligible originating sites. So eligibility, originating site eligibility is determined based on its status, the status of a HIPSA as of December 31st of the prior calendar year. So there are no mid-year changes to these definitions, but CMS has provided a website tool that sites can use to identify whether or not they would qualify. I've put on this slide some of the eligible originating sites. I don't think there's anything that needs to be explained further here, but it's important to note that independent renal dialysis facilities are not explicitly not eligible originating sites. On this slide, we have the distant site practitioners that are considered eligible distant site practitioners for telemedicine or telehealth reimbursement by Medicare. And then finally, the last requirement I'll discuss is what type of medical services are eligible for Medicare telehealth reimbursement. And in general, the services that are eligible include consultations, office visits, individual psychotherapy, and pharmacologic management delivered via a telecommunications system. So it's really important to know that an interactive audio and video telecommunications system has to be used that permits real-time communication between the distant site practitioner and the patient. That is sort of a key requirement for telehealth reimbursement by Medicare. And the fee schedule includes a list of the Medicare telehealth covered services by code. I didn't include that list. It is getting longer and longer, but I'm happy to provide that to anyone or follow up with you if you have specific questions about whether a code or service is included on this list. So the reimbursement to the distant site professional who's delivering the service via telecommunication is the same as the current fee schedule amount, and the CPT code for the professional service needs to be submitted using the GT modifier, and this just indicates that it was delivered via interactive audio and video telecommunication system. And the originating site is also eligible to receive a facility fee in connection with a telehealth encounter, and I've included the specific CPT code here that should be included to receive that fee. Just a couple quick updates for 2014. CPT codes that I've included on this slide relating to transitional care management services were just added this year as telehealth coverage services. I should note that there's a limit of one telehealth visit every 3 days for subsequent hospital care services received under these codes, and also a limit of one telehealth subsequent nursing facility care service received every 30 days. The final thing I want to mention with regard to Medicare reimbursement is that there are instances in which services that are delivered via telecommunications may be covered as physician services, even if they're not specifically reimbursed as telehealth services. So I've included on this slide from the benefit policy manual that a service may be considered to be a physician service where the physician either examines a patient in person or is able to visualize some aspect of the patient's condition without the interposition of a third person's judgment. So this includes direct visualization by means of x-rays, electrocardiogram, tissue samples, etc. For instance, this can include interpretation of an electrocardiogram that's transmitted electronically rather than verbal description. And these are instances in which a patient, is not present. And again, it's not considered telehealth, but I thought it's important to at least mention this because these services are also delivered, are also eligible for Medicare reimbursement and covered in the same way as if the physician service was delivered on site. With that, I am going to move over to transfer this to Ryan to talk about the corporate practice of medicine.
All right, thanks, Catherine. As we said earlier, many for-profit business entities owned by non-physicians are entering the telemedicine space. For those businesses and for those physician groups, hospitals, health systems that enter into agreements with those kinds of businesses, it's important that the arrangements be structured to comply with state corporate practice of medicine prohibitions. The corporate practice of medicine prohibition doctrine prohibits corporations from employing medical professionals or owning or controlling medical practices. Now, these laws vary across states. Some states don't prohibit the corporate practice of medicine. In some states, it applies to physicians. Others, it covers other healthcare professionals. The important takeaway is that, again, if you're entering into an agreement with a for-profit business, or if you're a for-profit business entering into the telemedicine space, that your business model, that your arrangements are drafted, are structured to comply with any state corporate practice of medicine prohibitions. Now, this prohibition was intended to prevent lay persons from exerting control or influence over physician or other clinical decision-making by healthcare professionals. And it's often used for that reason when it's enforced, but it's also used oftentimes to limit the entry of disruptive innovation into a state. And so, innovative models that use telemedicine, at-home diagnostics, or have significant resources behind them that are going to create disruption in an existing state, well, those businesses might be examined more closely by state medical boards or AGs who want to make sure that local businesses are protected from, again, outsiders. Now, this prohibition has been widely criticized as being out of sync with the way medicine is practiced today, but it is the law in the majority of states in the U.S. Now, the corporate practice of medicine prohibition is based on state statutes, case law, attorney general opinions, board policies, etc. As I mentioned earlier, the prohibition, the nature of the prohibition varies by state, but also the amount of enforcement varies by state. Some states are much more active in terms of looking at arrangements to see if they violate state corporate practice prohibitions. Some states are much more active in going after businesses that they feel might be violating those prohibitions. For example, California and New York. Wherever you have sufficient population density, it seems like you have more active corporate practice prohibition enforcement. Many states have exceptions from the corporate practice prohibition. Entities owned solely by licensed professionals, professional corporations. Many states accept hospitals from the corporate practice prohibition. Again, the important takeaway is if you're operating a multi-state business, or if you're, you have to make sure you understand what corporate practice prohibitions exist and how to tailor your business model to make sure you comply and don't run afoul of those prohibitions. So what are the potential ramifications of violating a state corporate practice prohibition? Sometimes payers simply refuse to pay claims. Many cases that you see out there, it's private insurers refusing to pay for health care services that were provided in an arrangement that the insurers allege violates a state corporate practice prohibition. Sometimes you see injunctions on the continued operation of the health care provider. In this case, it would be a telemedicine provider. Scarier yet, there could be criminal prosecution for engaging in the unauthorized practice of medicine. If you're a for-profit business, you're a non-physician, you start offering telemedicine service in a state that prohibits the corporate practice of medicine, and you're doing that through healthcare professionals you employ or you control, you could find yourself on the receiving end of a criminal prosecution for engaging in the unauthorized practice of medicine, engaging in the practice of medicine without an appropriate state license. Also, arrangements could be declared void. If you're entering into an arrangement with a telemedicine company owned by a for-profit business or non-physicians, or if you are that business and you have an arrangement with a hospital, a health system, or a physician group, a court could find the entire arrangement, including non-competes, licensing of technology, fees, to be void. You could have a technical violation of certain fraud and abuse laws, for example, the False Claims Act, and various exceptions that physician groups, nurse practitioners rely upon from various state licensing requirements, certificate of need, lab licensure, etc., may be at risk of loss if it turns out that you violate a state corporate practice prohibition and are not truly operating as a private practice. So, potential solutions to the corporate practice of medicine problem. A fairly common model that's used to comply with state corporate practice prohibitions is the management company model. And many of you have probably seen this, you're familiar with it, but in this model, you have two entities. You have a professional corporation, which provides all the clinical functions. That could be owned by physicians, nurse practitioners, physician assistants, etc. You also have the management company, and that's owned by for-profit companies, private individuals, non-physicians, some combination thereof, but that company provides all non-clinical functions under a management services agreement. For those of you who like diagrams, this shows you what that model looks like. You have the management company on the left, which again is owned by for-profit individuals, for-profit businesses, non-physicians. That entity provides administrative services, non-clinical services to a professional corporation, which is in turn owned by licensed healthcare professionals, those who can provide healthcare services compliant with state law without running afoul of the corporate practice prohibition in that state. The management company, in return for providing all the administrative services, the technology, marketing support, billing and coding assistance, et cetera, receives a management fee. The amount of control the management company can have in this scenario, the nature of the fee, the amount of the fee, you really have to look closely at state law to make sure this kind of arrangement isn't structured in a way that would allow an attorney general, a medical board, to successfully argue that the management company is the true provider of the clinical services, those services it cannot provide under applicable state law. And that's a state law question. Again, the states that prohibit the corporate practice all look at this differently in terms of how much control the management company can have and how that management fee can be structured. The management services agreements are typically long-term. There's often restrictions on termination. They often have non-competes. There's obviously a management fee, and again, how that's structured, if it's a percentage-based fee, a flat fee, how high the fee is, that has to be looked at very closely to make sure it doesn't create any serious corporate practice of medicine issues or fee-splitting issues or issues under the federal anti-kickback statute or Stark law, which we'll talk about in a few minutes. So the risk with the management company models I mentioned earlier, the owners may seek to void the management services agreements. Many of the cases out there again are brought by payors who are refusing to pay claims, or they use that as a defense when a provider seeks to collect payment. But many of the other cases that are out there, it's really the owners of that professional corporation who either want more money through reducing the management fee or higher compensation. So if you enter into an arrangement, this management company model, make sure you know who the owners of that professional corporation are, because they're often the source of many claims or actions that try to attack the model based upon corporate practice medicine prohibitions or fee-splitting prohibitions. Licensing board issues, the healthcare professionals who are involved in an arrangement that's viewed as being violating the state corporate practice prohibition, their licenses are at risk. It's hard to protect them in terms of indemnification, because if they lose the license to practice, that is a big issue, and that's often an issue that's negotiated pretty heavily in setting these types of arrangements up. All right, fee splitting, I'll mention this briefly. Many states prohibit fee splitting. There's a perceived danger of allowing professionals and non-professionals to share in the income from the professional services of healthcare, licensed healthcare professionals. The concerns that there be a temptation to maximize profits through medically unnecessary services, or a temptation to limit medically necessary services to maximize income. Again, it's a state-specific issue. Percentage-based fees are more risky than flat fees. But when setting up an arrangement where you have non-healthcare professionals, you want to make sure that the arrangement complies with state fee-splitting prohibitions. All right, this would not be a healthcare webinar without some mention of the federal anti-kickback statute, which, as most of you probably know, prohibits the offering, paying, soliciting, or receiving any remuneration in return for business for which payment may be made under a federal healthcare program, Medicare, Medicaid, TRICARE, or reducing purchases, leases, orders, or arranging for any good or service or item paid for by a federal healthcare program. Now, remuneration is defined very broadly to include kickbacks, bribes, rebates. It can be in cash or it can be in kind. It can be direct or indirect. We're not going to go deep on the anti-kickback statute, but it's worth noting that there are significant penalties that can apply for violating the anti-kickback statute: criminal and civil penalties, imprisonment, civil monetary penalties. There can be False Claims Act exposure. So it's important when setting up a telemedicine arrangement to make sure that the various relationships at play do not run afoul of the anti-kickback statute or create any serious regulatory issues. What relationships should be examined? Relationships with supervising and collaborating physicians, relationships with hospitals, health systems, and relationships with other entities, management companies, if you use that structure, a telemedicine company, licensing company, et cetera. I mean, you have to look at the whole arrangement, all the various aspects, to make sure that none of the relationships create significant risk under the federal anti-kickback statute. So it's important to remember that there's no issue if a federal healthcare program reimbursement is not involved. Many new models in healthcare try to avoid dealing with Medicare and Medicaid whenever possible, to avoid some of the significant regulatory problems that can occur if you run afoul of the various rules and regulations that apply to federal government programs. But it's important to remember that many states have their own anti-kickback and self-referral prohibitions. And in many of those, the source of payment, be it governmental or non-governmental, is totally irrelevant to whether those state laws apply or if they've been violated. So if you're setting up this model and you decide to avoid federal healthcare programs, you still have to examine state law to make sure that the model complies with all these state-specific anti-kickback and self-referral prohibitions. So the Stark Law, briefly, prohibits a physician from making a referral for certain designated health services to an entity with which the physician or an immediate family member has a financial relationship, unless one of Stark's many exceptions applies. Stark also prohibits entities from submitting claims for designated health services provided pursuant to a tainted referral. Now, the anti-kickback statute is intent-based, but the Stark Law is a strict liability statute, meaning that the intent of the parties is totally irrelevant for purposes of determining whether the law has been violated. Stark provides penalties, again, and requires the refund of amounts for illegally referred DHS. The takeaway for now is if you're setting up one of these telemedicine arrangements, you want to make sure, you want to determine whether Stark applies at all, and if it does, that all of the various aspects of the arrangement fit into an applicable Stark exception. All right, so malpractice. So obviously if you're providing health care online, there is a risk that a plaintiff's attorney will bring a malpractice claim against one of your providers. In America, litigation has been said it's a national pastime. Now, the growth of telemedicine will result likely in an increase in the total number of malpractice claims against telemedicine providers. This is an evolving area of law with respect to the standard of care, jurisdiction, etc. But a bit of MedMal 101. To succeed on a medical malpractice claim, a plaintiff has to prove certain things, including that the physician or the other healthcare professional had a duty to the patient. You have to prove the existence of a physician-patient relationship. Okay, and if that exists, there's a certain standard of care that will apply. There'll have to be a breach of that duty. There'll have to be damages which were caused by the breach of that duty to the healthcare professional or the physician or the patient. Now, it's important when structuring telemedicine or online consultations that physicians and other healthcare professionals do not inadvertently create physician-patient relationships through online communications with patients. And that's part training, that's part policy. You might consider disclaimers on the website to make sure that you don't find yourself again at the receiving end of a malpractice claim for inadvertently entering into a physician-patient relationship. Jurisdiction, not a lot of activity. There is one example. This is a criminal case that came out of California. In this case, a physician named Hegseth was found to have violated California law. It was a criminal case in which Hegseth was found to have been practicing without a license in that state. Hegseth prescribed medication over the internet to a California patient. The patient subsequently committed suicide and was found to have alcohol and the antidepressant prescribed by the physician in the patient's system. Hegseth tried to escape prosecution by arguing the California courts did not have jurisdiction. He prescribed the medication outside of California via the internet. However, the California court found that since the detrimental effect of the physician's prescription took place in California, the California courts had jurisdiction over the physician. I think you can assume that similar analysis would be done by most courts if someone's providing telemedicine in a state in which they are not physically present. Some recommendations on how to minimize malpractice risks and risk management generally. Peer review is important. There should be robust physician chart review. Telemedicine providers should monitor developments in clinical practice guidelines and use evidence-based guidelines whenever possible. It's important to make sure you have insurance coverage. Look at the policies closely. If possible, get a written assurance from the carrier that the telemedicine services you're providing, in-state, out-of-state, across the U.S., that those services are covered. You might want to consider limiting the scope of practice of the services offered online to make sure that those services offered via telemedicine, online consultations, are appropriate for that kind of patient encounter. As we'll talk about in a few minutes, the AMA and the Federation of State Medical Boards has also emphasized the importance of ensuring continuity of care and providing for emergency services whenever appropriate. Other recommendations, of course, know the applicable law instead of care in the jurisdictions in which you're going to operate. Make sure you don't overpromise anything in advertisements or other communications. Limit physician communication, other healthcare communications online, again, to make sure you don't inadvertently create a healthcare professional-physician patient relationship because there can be a lot of costs in doing so. Have appropriate training, allow adequate time for patient encounters online, and ensure, as Catherine mentioned, both for regulatory reasons, also for risk management reasons, appropriate supervision when using nurse practitioners, LPNs, or PAs to provide telemedicine services, document the encounter with the patient, and the informed consent. Some recent guidelines, as I mentioned, the Federation of State Medical Boards recently adopted a new model policy on the use of telemedicine. The AMA also released new guidelines regarding telemedicine in June 2014. The Federation of State Medical Board policy defines telemedicine as the practice of medicine using electronic communications, information technology, or other means between a licensee in one location and a patient in another location, with or without an intervening healthcare provider. Now, the focus of this policy is really on the direct-to-consumer report. The policy was designed to provide flexibility in the use of technology by physicians, ranging from telephone and email interactions to video conferencing, as long as the providers adhere to recognized patient standards of care. The policy explicitly does not cover physician-to-physician consultations. Again, this is really a direct-to-consumer policy. Some important aspects of the policy. The model policy emphasizes the importance of establishing a valid physician-patient relationship. Under the policy, such relationships are established only when the physician and the patient agree that the physician will be responsible for diagnosing and treating the patient. The policy also encourages telehealth providers to verify patient location, disclose physician identity and credentials, and gather all required consents when establishing that relationship. The model policy also addresses standard of care issues, recommending that providers be held to the same standard of care for telemedicine as in traditional in-person visits, meaning that telemedicine providers should conduct appropriate medical evaluations of patients, including the collection of medical history and appropriate diagnoses and treatment recommendations based upon patient-specific facts and circumstances. As I previously mentioned, the model emphasizes the critical importance of ensuring continuity of care and appropriate referrals for emergency services for patients of telehealth and telemedicine providers. The AMA recommendations are very similar to the Federation of State Medical Board recommendations. The AMA recommendations divide telemedicine into three categories: real-time interactions through an online portal, which is really our focus today, remote monitoring through devices, and store and forward practices. The AMA recommends that telemedicine services be covered and paid for if certain conditions are met. You have a valid physician-patient relationship, you're complying with state licensure laws, you're complying with evidence-based guidelines, you're collecting appropriate patient history, you're coordinating care, you have an emergency referral protocol, there's transparency in who's providing the services, where they're being provided, etc. So, stay tuned. These are recommendations from both the Federation of State Medical Boards and the AMA. I think it's helpful guidance. I think it points in the direction that you're going to see regulations in the states developing, as well as additional guidance from the federal level. With that, that is Telemedicine Legal and Regulatory Issues 101. We will now turn to any questions you might have in the few minutes we have remaining.
So I have one question here, which I think is sort of an interesting issue. It states that if a medical device company employee, quote, practices medicine, in other words, programs a medical device remotely, is it subject to telemedicine regulation or potentially considered the corporate practice of medicine in a state? So I think, again, you really are going to have to look to individual state definitions of the practice of medicine to determine what types of activities fall within that definition in a particular state.
Yeah, you would generally, programming a medical device remotely will not be deemed to be the practice of medicine. But again, it's very important to look at state law to see what guidance you have, and every state is different.
Yep, some states define it, the practice broader than others,
Right.
but in general, I think the risk would be pretty low that that would fall within that definition.
Agreed. All right, and we'll just wait another minute or so to see if other questions roll in. All right, so we have a couple very specific questions that we'll follow up on after the webinar. Thanks for listening in. As I said, this is just an overview, and we hope to provide additional guidance via future webinars, publications. Feel free to reach out to Catherine or me with any specific questions we did not cover today, but thanks for listening.
Thank you very much.